weren't able to make it. And I totally understand that because I have a young daughter myself, and sometimes it's hard to be able to do all the things that you had hoped to do, especially right now. So, my name is Laura Fillenworth. I'm the executive director at Keen Chicago, and we we're connected with Brad Dembs. I'll let him introduce himself. He offered to run a resource workshop for us, and I think it's going to be a really great resource for our families. And yeah, we're happy to see everyone here tonight. So if you have questions, feel free to ask in either the chat or unmute. I'm going to keep everyone muted during the presentation, but if you do have a question, I think it's okay to unmute. So Brad, I'll let you introduce yourself, and we'll probably still have others joining.
Sure. So hello, everyone. My name is Brad Dembs. I am an attorney here in Chicago. I work for a law firm called Matt Cohen and Associates. We focus first and foremost on special education law. We represent families of children with disabilities who may be having disputes with their school districts already about issues related to their children's education, or who think that they might have issues coming up that they want to consult with an attorney on. Sometimes we represent parents and their kids all the way through legal proceedings against school districts. But more often than that, we usually help them resolve disputes more informally. That can be through settlements, mediation, and we'll talk more about what those things look like down the line here. But what Laura and I thought would be a really helpful presentation to share with you guys today is sort of what you see on the title here: IEP key components and advocacy tips. So some of this may be a refresher for you about the IEP components. I'm sure a lot of you have been to a lot of IEP meetings. And if that's the case, hopefully what you're hearing today is a good refresher for you on things that you may have experienced yourself in your IEP meetings. And then I'm also going to give you some advocacy tips from my experience and the experience of my boss in the firm regarding what we've seen over time that's helpful and not helpful for parents to keep in mind during IEP meetings and before and after. So I'll jump right into it. And like Laura said, if you have questions, feel free to ask in the chat. Laura, if you see something that's especially pertinent to hit right in the moment, please feel free to interrupt me. Otherwise, we can wait to the end, and I'll be happy to answer any questions that come up.
Yeah, I see. If I see questions coming through, I'll try to point them out. Yeah. So, and I know some of our athletes are here too, and they might use the chat, and that's great. So feel free to do that, but I'll try to call out any questions that are coming through.
Okay. So the first step in determining what a child needs is to evaluate. And so conducting an evaluation to determine special education eligibility or to determine what areas need to be addressed in an IEP requires informed parental consent for all evals and re-evals. So every time the school district wants to do an evaluation, they need to explain to the parents, or if your child's 18 and they have decision-making authority for themselves, then explain to the student and get their consent for what evaluations are going to be done. The IDEA is the specific law that most of what we're talking about falls under. That's the Individuals with Disabilities Education Act. So if you see IDEA or hear me say IDEA requires, we're talking about the federal law for special education. Okay, so the IDEA requires that in conducting evaluations, school districts have to use a variety of assessment tools and strategies. They can't use any single measure as the sole criteria to determine if a child has a disability. And they have to use technically sound instruments. And also you'll see in this first sub-bullet point here, they're gathering relevant information, not just academic information, but functional and developmental information as well. And that's really important to remember and keep in mind for all aspects of, education. It's not just academic. Education means functional performance too, so that.
No, he's not a minor. He's 18. Let's.
I'm gonna try to go through and make sure everyone is on mute. If you notice that you're unmuted, just try to mute yourself.
Okay.
Thanks.
Great.
So moving on then, evaluations have to be non-discriminatory. That means they have to be provided in the language and form most likely to yield accurate information on what the child knows and can do. So what that means is that school can't conduct an evaluation that requires verbal responses if the student is nonverbal, right? That wouldn't make sense. That wouldn't result in a real understanding of what that student can do. So it's important if you are a parent to think about what evaluations are being conducted and whether they're actually in the form most likely to yield accurate information about your child. And if you have concerns, you can raise them at any time. Evaluations have to be done within 60 days, so right around 2 months of parent consent, unless your state specifies otherwise. I know we have some people here from out of state, not in Illinois. Some of what I'm talking about may be specific to Illinois, but I'll try and make that clear. And for most of what we're talking about, it falls under this federal law, which means it's the same in every state. So there can be some flexibility about how long it takes to conduct an evaluation if it's agreeable to both parties. But the law says that 60 days is what they have once you give consent. And requesting an evaluation doesn't automatically mean that you've given consent, because remember, you need to receive information from the district about what evaluations they're proposing. And then once you're informed, you can give informed consent. There's also something called an independent evaluation, which comes up if a parent is not satisfied with a school district's evaluation, then you can request an independent evaluation at school district expense. So this means if the school did an evaluation that didn't result in the conclusion that you were expecting, or you disagree with any aspect of how it was done, you can raise that concern and let them know that you want an independent evaluation at district expense. It's like getting a second opinion from someone who's not affiliated with the school district. So because you're essentially disagreeing with a district evaluation, there has to be an evaluation that was completed that you disagree with. But there are some circumstances, like if the school district refuses to do an evaluation or ignores your request, that you might be entitled to get an evaluation on the theory that they missed their opportunity to do it. But you do need to give them a chance to do their own evaluations first. And once you request an IEE, which has to be signed, dated, and written, once you do that, once you give the district that request, they have only two choices in how they respond. They can either agree to do the evaluation, or they can request a due process hearing to essentially prove that their evaluation was appropriate and there shouldn't be a need for an independent evaluation. Most of the time they will agree, although there are some circumstances we've seen recently where, especially if a parent is requesting an IEE without having an attorney supporting them, that the school district will file for due process in a sense to intimidate parents and try and get them to withdraw their request. So the information needed in order to develop an effective IEP is listed here. And we'll go through all of these in more detail on the following slides. So this is just an outline of what's coming up in the next slides. The FAPE standard, FAPE stands for Free Appropriate Public Education. And that's what all children with disabilities are entitled to if they're eligible for special education. So what is a free appropriate public education, or a FAPE? Well, there was a recent Supreme Court case within the past 5 or 6 years called Andrew F. And in that case, the United States Supreme Court created a new standard for what a free appropriate public education is. And basically what they said is that there have to be challenging goals based on a child's individual circumstances. The child has to achieve more than minimal benefit from the services they're receiving. And passing from grade to grade is only one measure of progress. So even if a child is making progress by passing from grade to grade, that doesn't necessarily mean that they're receiving a free appropriate public education. You really need to look at the individual student's needs and make goals and then services to help them accomplish those goals based on what can realistically be expected for them to accomplish. And so that comes from having quality evaluations too. So you know what a child can currently do on all of these skills, and then what's realistic for them to achieve. And then you create your goals from there. So what are students presenting problems? What do parents report to be the student's needs? Important to note for all of you parents, parents are a part of the process, okay? Parents are required to be a meaningful participant in the IEP. And that means that the school district has to listen to parents' concerns and has to address them. We'll talk about that a little more in a few slides. But when parents report students' needs, it should be discussed and considered how does that compare to the school's identification of a child's needs and to clinical diagnoses. And then you should ask, is there an agreement among the parties about the extent of the child's needs? Sometimes school districts will really downplay a student's needs for various reasons. They may not want to provide services that a child really needs. And just as a disclaimer here, a lot of what I'm talking about is going to be from the perspective of what can go wrong, because that's the only time that I get involved. So, you know, I know that there are a lot of schools that do a really good job, and we're always happy to hear positive stories as well. But a lot of what I'm presenting to you today will be to tell you what to look out for and what school districts may do that's not right. But that doesn't mean that I don't think there are good school districts out there. So with that disclaimer, you really want to think about heading into an IEP. What are you trying to accomplish? What skills are you trying to address that your child needs to develop? And within those skills, what are your priorities, right? It's certainly possible, depending on how many challenges or skill deficits your child has, it's certainly possible to address all of them in one IEP, but you should take stock of what's your priority in this meeting? What are you trying to accomplish now? And what are skills that are necessary sort of stepping stones to further skills, and really focusing on what needs to be accomplished in this present moment at this IEP meeting. Another important point, the last bullet here, is how much time is available until graduation for them to do this, right? So if your child is approaching graduation age, which doesn't necessarily mean 18, by the way, in Illinois, children are eligible for special education until they turn 22. And to correct myself immediately, more specifically, they're eligible for services until the end of the school year in which they turn 22. So school year starts in August and goes until June. If they turn 22 in September, they're still entitled to services for the rest of that school year. But that really depends on the school district and yourselves agreeing that the student needs ongoing services. And that's a decision that's based on a lot of information that we'll talk about. Is there enough information to support what the child needs? Again, take stock of what you're bringing to the table at the IEP meeting. You can't advocate for an appropriate IEP without knowing what the child's disabilities are, how severe they are, what's been successful in the past, and so on. So it's important if you're working with outside providers, if you have an ABA therapist that sees your child at home or in a clinical setting, if you have a speech language therapist, depending on what you've got going on with Keen, maybe someone can write a letter for you about their work with your child in whatever aspect you're being serviced by them. The point is, if you have outside providers, use them, ask them to provide information that could be helpful in presenting the school district with a picture of who your child is and what their needs are. And then what's needed to accomplish the desired progress? What types of services does the child need to make meaningful progress, and what level of intensity? So how many minutes per week? What methodology, meaning like if they have a reading disability, for example, do they need research-based, multisensory curriculum? And what level of teacher training is required to provide that methodology?
I just had sorry, I don't mean to interrupt. We just had a question come through the chat, and I just want to call it out before it gets lost. So it says, what about progress in general ed curriculum? Have you seen any areas that use essential elements of Common Core for higher need students?
Sure, yes. I mean, curriculum is really ultimately, it depends on what your child needs and can be individualized or should be individualized accordingly. So yes, components of Common Core can be included in that. And, part of what you're looking at is, can your child make progress in light of their individual needs? But you also want to see, depending on what their needs are, can they make progress commensurate with their peers in a general education curriculum? So that's all needs to be discussed, and you should have a good understanding from the school district about what curriculum is being implemented for your child. Oftentimes, school districts are given the benefit of the doubt by a hearing officer, if you get that far, regarding what curriculum they choose for your child, but that's not an absolute. So if you have support indicating why certain curriculum is necessary, that's important to present and advocate for as well. Then another big question is, where are you trying to accomplish this? Given the child's needs, where do parents see them being appropriately educated? And what about recommendations from outside evaluators and clinicians? For example, we have a lot of clients who feel that their children need a more intensive placement than a public school setting. Maybe the school district thinks that the child should be in a categorical classroom or a classroom that's solely made up of students with autism, but they may not have the specialized curriculum and supports to meet that child's needs. And in that case, we may advocate for the child to be placed in a therapeutic day school that is specifically designed to address the needs of that particular child. And that can lead to a dispute with the school district about placement. But the flip side of that scenario can be true as well, right? The school district could be saying, your child's needs are so severe, we need to move them out. And you say, well, gee, I don't think so. You should be able to accommodate them in the general education setting with some extra supports and services. And if you're saying that, you're absolutely right. There's something called the least restrictive environment mandate. And what that means is that school districts have to try to provide services to a child in the general ed setting before moving them to a more restrictive placement. So that can be helpful if you're arguing for general education or for inclusion, but also school districts sometimes use that to say that they can't place a child in a more restrictive setting like a therapeutic day school because they haven't tried everything in the general ed setting yet. So it really depends on whether you have documentation or recommendations for the placement that you're looking for, and also considering what's practical under the circumstances of where you live. You know, we had a case with a young man with pretty severe autism, and we were advocating for him to be placed in the general education setting with supports because there really wasn't a viable program for him other than that. This was a rural setting, and there weren't good therapeutic day schools to meet his needs. So we were saying that the school district really needs to step up and provide him what he needs in that setting. If we had been doing the same case in Chicago, we may have argued for a therapeutic day school because that's more aligned to what he really needs. But you just sort of have to be realistic about what's possible, but never be afraid to ask for what you feel your child needs in terms of placement.
We've had 2 questions come through the chat. So one, is it okay if I ask them, or do you want me to like copy and paste and hold them to the end?
Go for it.
Okay, so the first is, in the event that they can't accommodate, will the district pay for students to get services outside of CPS?
They should. Whether they will or not depends on whether they agree with you that they can't accommodate or that your child actually has those needs. Oftentimes, when I'm in an IEP meeting, I feel like the parents and I are talking about a completely different child than what the school district is describing. And that can be really frustrating. And that's also why it's really helpful to have outside support from clinicians who are working with your child outside of the school setting.
And then the second question is kind of a big one, and you might have some of this later in your presentation. I'm not sure, but I'm going to ask it so it doesn't get lost because I think it's an important one. It says, have you had many complaints pursuant to the pandemic, and are districts getting away with providing fewer services because of it?
So I'll touch on this now in response to the question. Yes, we've been getting complaints about, during remote learning, we got complaints about how it wasn't sufficient for a lot of kids with disabilities who couldn't attend to the education remotely through their computer. Some kids had one-on-one aides in their IEPs for that particular reason, to help them attend to education in person, and then they weren't provided the one-on-one aid in person, in person when they were at home, and they really couldn't pay attention. We've also had some cases since schools have gone back in person where the transition has been difficult, or where parents didn't realize until the child was back in school how much they actually missed. And in those cases, we can request what's called compensatory education, which is essentially a remedy for the school district's failure to provide appropriate services. So just keep that term in mind, and we'll hit on that more down the line.
Thanks.
Thank you. So again, I mentioned this a little bit before, but what's the level of urgency? How close is the student to aging out of services? What are you asking for that's needed in the immediate term versus what would be needed in the future? What kind of plan do you need here? Short term to address an immediate issue, or looking more long term?
So sorry, I had one more question. It says, what about disagreeing with the evaluation for further eligibility determination? They state they don't see autism even if there is a medical diagnosis and the written evaluation provided describes autism symptoms.
Okay, so with autism specifically, we get this question a lot because the clinical diagnosis doesn't match up one-to-one with the requirement or the definition of autism under the IDEA, under the federal law. So sometimes if a child has a diagnosis of autism from a clinician, the school district will say that they don't actually meet the definition to warrant special education. If that's the case and you disagree with the result, you can certainly request an independent evaluation. If you already have an independent evaluation that has diagnosed with autism, you could go back to that person, that clinician, present the school district's evaluation and ask them to weigh in. Ask them to weigh in specifically on the school district's definition of autism and whether your child should meet that or would meet that. So moving along, it's just a reality that something off the shelf is always easier than a customized program. So ask, what are you looking for that they already have that they can provide versus what do they need to provide that they don't have. So to take the previous example of a child who needs a research-based multisensory reading program, the school district may not have staff that can provide that, so they would need to hire a new staff person to do that. And that's a much harder request than asking them to provide just more reading support by the special education teacher in the school. But if it's what your child needs, then you should feel strongly about advocating for that. Just need to be aware that there may be pushback depending on if it's something that the school district already has in-house or something that they would need to seek outside. So before entering an IEP meeting, you should decide what type of meeting you want to have and what type of IEP your student needs. And things don't always go according to plan, but for example, the first bullet here, procedurally compliant or loose, detailed needs statement or vague, aggressive goals are easy to meet. So really what we're looking at here is, if you feel like the school district can't meet your child's needs, then you don't want to go through a whole IEP meeting where you're strengthening the plan as much as you can if you think that no matter how strong the plan is, it's not going to meet your child's needs, right? That only makes your case for, say, a different placement harder to make. The better the IEP, the harder it is to make the case that the school district can't meet your child's needs. So if your goal is to get your child into a separate placement like a therapeutic day school, then you may just want the IEP to remain or to be less ideal. And that may mean not advocating as strongly for things in the meeting, but that's also a fine line because you don't want to give the impression that you don't care or that you're in agreement with everything the school district is doing. So in those scenarios, what we often advise parents to do is to have a statement regarding their concerns and essentially say, I don't think that you're capable of meeting my child's needs in this setting. They need a therapeutic day school placement, and sticking to that message. So saying that in response to things, if they say, well, we can increase reading support, isn't that good? We've made new goals that meets your need, meets your concerns, doesn't it? Just repeating, we don't believe that our child can be successful in this setting. They need a therapeutic day school. Okay, so you're not giving them suggestions on how to improve the plan, and you're making it clear where you stand on the changes that they're proposing. So here are all the steps of the IEP and what's included in an IEP. And we're going to talk about these in turn. The label. The label means what category your child is eligible for special education under, whether it's autism, speech language impairment, specific learning disability, and so on and so forth. The label should match your child's needs. And a label is essentially an opening of the door saying your child is eligible for special education. Once your child's eligible, they're entitled to receive whatever services and supports they need, regardless of their label. So the school district can't come back and say, oh, well, they're eligible as a student with a learning disability and reading, so they don't need any social work support, right? That doesn't make sense. What the school is required to do is identify eligibility through a label, but then provide all the services and supports that are needed regardless of that label. A label can be relevant when you're looking at a specific placement. If you're looking at a therapeutic day school placement or even a residential placement, some of them are only approved to take children with specific eligibility categories or labels. So that's something to keep in mind. Student strengths is a section where you get to brag about your kids. What do parents want to do more than that? And you should be robust. I don't think it's difficult to, for parents to brag about their kids or to say things that are great about their kids. So, feel free to use this as an opportunity to, speak at length about what your child can do, including both academic skills and non-academic functioning. Also, if this is an inclusion case, if you're trying to advocate for your child to remain in the public school setting, really describing a strong or a large group of strengths is important to portray why your child is capable of staying in that inclusive setting. Parent concerns.
So sorry, I've had 3 questions come through, but I think, do you want to wait until you're done talking about the IEP and then I'll kind of ask you all or ask them all, or what do you think?
Yeah, let's do that.
Okay.
Okay. Parent concerns is a section of the IEP where you get to set expectations and raise concerns about what you feel like your child needs. This is a section where you can raise things that may not be reported elsewhere in the IEP. If you feel like the school district hasn't been communicating with you properly, you could say that here. That's a bit adversarial, but depending on the posture of the meeting or where you're already at, you may want to say that. So it's noted, so it's acknowledged. And the school district is required to address parent concerns throughout the IEP. You can also prepare a written statement if you want to give it to them ahead of the meeting so they're prepared to discuss your concerns. And also they cannot tell you that your concerns are too lengthy for the form. They can always attach a printed out version of your concerns to the IEP. So you are never limited in terms of how many concerns you can raise. PLAF means the present level of academic achievement and functional performance. So that includes academic and non-academic performance. And you want this to include actual data, right? Because this is where the goals draw from. So we need measurable actual data about what the child can do and what they can't do, so that we know how to write the goals. You want to look at strengths and weaknesses depending on your goals. Again, to reiterate, maximizing weaknesses when you're seeking a more intensive placement or services, and minimize when you're seeking inclusion. But this doesn't mean to lie or to mislead. This just is being strategic about how you're framing the needs and the strengths and weaknesses of your child. And then we get into goals. And this is often a part of the IEP that a lot of parents and even attorneys can sort of get glossed over, and it's very detail oriented and very specific, or it should be, right? And sometimes it's hard to know if a goal is appropriate or not. So what we want to do is, when we're looking at annual goals and short-term objectives that build towards that goal, again, we want to be relevant, and we want the goals to be measurable. So we want to be looking at what's that data that was collected, how many words can the child read per minute now, and what's realistic for them to get to by the end of the year. You can also try and be strategic about having the goals embed the placement that you want. So if the goal says, given instruction using a research-based multisensory program, the school district kind of has to provide a research-based multisensory program. Otherwise, they're not even working towards this goal. But they know that too. So, if you're trying to slip that in, slyly without them knowing, and then say, gotcha, you have to provide this, that's probably easier said than done. But if they agree that the child needs this, then they should absolutely include it in the goal. I've already talked about the need for baseline data, and here's an example. So if the baseline, the measurable data is that the student can independently read grade level text at 45 words per minute with 90% accuracy, now the goal would say by a date 1 year from the meeting, the student will be able to read text at 90 words per minute with 90% accuracy. So we're really targeting the reading rate here, words per minute, right? Because the accuracy is the same, and we're looking at the same amount of trials. So we're looking to improve the reading rate. Consideration of special factors. This is just various things that may be or should be discussed to the extent needed. Does your child need assistive technology like a communication device? Do they have communication needs because they're deaf or hard of hearing, limited English proficiency, or visually impaired, or behavior? These are some things that are highlighted because they can be significant determinations of what services and supports are provided. Accommodations is a section where the district may provide things to accommodate your child by maybe removing requirements or giving them extra time. But you should really avoid optional accommodations. Like, be really careful about language that says as needed or at teacher discretion. This should really be something that doesn't give school districts wiggle room to not provide it because it wasn't needed or the teacher didn't think it was needed, right? It should say, in this scenario, this will be provided. And this is a good place to build in things that the school district wouldn't list elsewhere, like parent communication. We've had a lot of clients whose children are nonverbal, and so the child can't come home and tell parents how their school day went. So it's important to have a log, a home school communication log, where the teachers can report what went on at school that day, good things and bad things, so the parents are aware of what's going on. So another important consideration on accommodations, we call it the pitfall, is accommodations boost school performance, not student performance, right? An accommodation is something that you're giving the child a break on, or you're giving the school district a break on by saying, oh, you can accommodate that, but you don't have to provide services for that, right? So if you're providing accommodations, there should also be corresponding goals. So the student's building skills, not just being accommodated, as a Band-Aid for something that they can't do. So here's an example. If the teacher will check the assignment book for accuracy, should have a goal that the student will record assignments accurately. If a student uses word processor for essays instead of handwriting, it should say that the student will learn how to keyboard at least however many words per minute, whatever accuracy. So focus on what skills are being accommodated for, and make sure that you're also addressing those skills to build on them, not just accommodate for those weaknesses. Testing accommodations means standardized testing should follow the regular in-class accommodations and can include extra time, method of presentation, how the test is presented, etc. And then you get to educational services and placement. So minutes should spell out the location of where the child's going to receive their education, what subjects, what type of class. If your child's splitting time between a resource classroom and a general ed classroom, this page should really be detailed about what subjects, what times of the school day are going to be in what session or what setting. And then related services should be spelled out here as well. That includes speech language therapy, social work, occupational therapy, physical therapy, those sorts of things. It should be spelled out whether that's going to be pull out, where the child is taken from the classroom to work either one-on-one or in a small group with the service provider, or push in, where the service provider goes into the classroom. And the more narrow or specific the time frame here, the better. So saying that a child will get 30 minutes per week is better than saying that they'll get 120 minutes per month. Even if it says 120 minutes per month and they intend to provide it 30 minutes per week, that could include weeks where they don't provide the service. And maybe that's justified because there's any type of reason, staff person's not there. So there needs to be some flexibility, but in general, it's important to be more narrow than broad. And also don't allow consult time to be lumped with direct. Consult time is time when the service providers and the teachers are talking to each other about what the student needs, but it's not a direct service being provided to the student. So those should be kept separate. So 60 minutes of consult and direct could mean 60 minutes of consult and your child gets no direct services. So, with any plan or contract, which an IEP kind of is, you want to make sure that the terms are as specific as possible. So there's less wiggle room for the school district to get out of them and more ability for you to hold them accountable. We talked a little bit about LRE, and placement is really supposed to come after other components of the IEP. So you look at what the student's needs are, what the goals are, and then where those can be met. Sometimes it's good to try and leapfrog to placement first to determine if you're going to be fighting over other components or not. But that's, again, may be easier said than done, depending on the school district, depending on what's happened between you and the district in the past. They're also supposed to list the options considered along the spectrum of placements. So from least restrictive to most restrictive, and consider what's appropriate, including a consideration of what might be harmful to your child about the different placements. And then you want to ask about transportation. If it's needed, it should be specified in the IEP. Is a bus aid needed? Is a child required to be in a harness or to have their wheelchair locked in place on the bus? Those are things that should be discussed and written into the IEP. And then extended school year. Oftentimes this isn't decided until later in the school year, close to the end of the school year, before extended school year would start. And that's because the school district may say that they need to collect data to determine what the child needs and if they need extended school year. So these are services provided beyond the normal school year in accordance with the IEP, so same goals and at no cost to the parents. And the purpose of this is to maintain skills, not to acquire new skills, but to protect against regression, right? So if you can make a case that your child has shown regression in the past after a summer off, then you would have a good argument to make that they need extended school year so that they don't regress before the following school year. And this is typically less than the amount that's provided during the school year when the child is expected to make progress, right? Because we're just talking about maintaining what they already have developed. Another big component of an IEP is a transition plan. This is something that needs to be in an IEP for the first IEP that will be in place when a student turns 14 and a half, and then moving forward. This is thinking about what the child's, or at this point, young adults' goals are moving forward, looking ahead to their life after school. What do they want to be doing? And what is realistic for them to be able to do? And then what needs to be done between now and then to allow them to achieve those goals. So whereas IEP goals before you reach this age are really looking on an annual basis about progress that needs to be achieved, now we're looking at the future and working backwards and saying, this is where we want to get to for our child and what needs to be in place now to build towards that long-term goal. And in order to determine that, schools have to do evaluations to assess the child's needs in all areas of functioning. Again, not just academic, but now because we're looking ahead to the future, we're also talking about independent functioning, community living skills, vocational skills, everything that would be needed for them to be a safe and successful member of society to whatever extent is possible for them to do that. FBA and BIP means functional behavior assessment and behavior intervention plan. So you should be describing any characteristics that might make it difficult for your child to understand right from wrong, understand school rules, hear or actually respond to directions, interpret other students' behaviors, or control their own behaviors or impulses. So this is an opportunity to really describe how your child's disabilities may impact their behavior and to analyze what scenarios or environments might be triggering behavior issues. This should be included in the needs section of the IEP as well, but doing a functional behavior assessment to look at what happened before the behavior that might have caused it, what the behavior was, and what the consequences were can be helpful to create then a plan to sort of preempt behavior issues. This is the behavior intervention plan, and this is a document that essentially provides a roadmap in addition to the IEP on how to be proactive to prevent behaviors from occurring and how to respond to them appropriately when they do occur. There's also something called a manifestation determination review. You You can see this in the bottom line as MDR. This is a procedure where if a child has behavior issues in school that would cause them to be suspended or expelled, once there are 10 days of removal from school, so that can either be incrementally one day here and there, if it's the same type of behavior over a period of time that reaches 10 days, or if the behavior was so severe that the school's saying that they're going to suspend your child for 10 days or more or expel them. That triggers this protection for children with disabilities called a manifestation determination review. And when this happens, the school district is required to meet and determine one of two things. Was the behavior related to the child's disability, or was it a result of the school district's failure to implement the IEP? If they answer yes to either of those questions, they can't remove your child any further from school. They have to reinstate them in their program and provide an updated functional behavior assessment and behavior intervention plan. Now, that's not an absolute. If the behavior is so severe that the child is causing a danger to himself or others in school, then they may not need to return him to that setting. But in most cases, this means that the school can't exclude a child from school because of their disability-related behaviors. They have to figure out ways to address them proactively in the school setting. We're running low on time and we're going to have some questions, so I'm going to move past this. Nothing significant there.
I
Compensatory
have about
education.
5 questions that came through. So I've been collecting them, and then I've said, okay, we'll get through as many questions that came through that we can.
Yeah.
But we'll see.
So let me get through the next few slides and then we can jump into questions. Compensatory education is a remedy for a school district's failure to provide appropriate services. And what it's really intended to do is to place the student in the position they would have been in had the district provided those services. So it's not an opportunity to get extra support and extra services to go beyond what would have been provided. It's really services or even a change of placement to a more intensive programming to allow the child to make up for what was lost. So the threshold for determining if you're entitled to comp ed is whether the deprivation of services was significant enough to cause a lack of progress or a loss of educational benefit. The way that we calculate this is most often called qualitative. That means placing the child in the position they would have been in if not for the school district's violation. It doesn't mean that if your child wasn't provided with 30 hours of speech language services, that you automatically get 30 hours of speech language services as compensatory education. The school district could provide more intensive services that may be able to be provided in less than 30 hours or different services. So it's really looking at what's needed to get the child back to the position that they would have been in if services were provided all along. But it's also important to note as a caveat and as an advocacy tip, whether it's considered comp ed or not, the district has to consider the student's current needs. And here it says when school reconvenes in person. So that meant after remote learning. But in any circumstances, the school has to consider a student's current needs and build a plan around that. So sometimes school districts will push back if you say, I want comp ed, because what you're basically saying is, school district, you did something wrong and you need to pay me back for it. They might not want to admit that they did something wrong, right? All school districts are great. So instead of saying it that way, you could just say, this is what my child needs right now, and they're required to provide that. You know, of course, that's a conversation that would take place at an IEP meeting, but considering the child's needs at that time can help you to make up for what might have been lost, regardless of whether it's comp ed or not. But that doesn't mean you shouldn't advocate for comp ed if you feel like your child needs it, and especially if the school district is pushing back on what they need. And that's when we get into resolving disputes. If your school district won't provide appropriate instruction or services, if they won't find your child eligible for special education, or if they refuse to make reasonable accommodations, your next step would be either to file for mediation or a due process hearing or a state complaint, but most often it's going to be mediation or due process. A mediation request on its own is essentially just saying that you want a neutral third party to meet with you in the district to try and help you resolve the dispute. There's no obligation to do that. The school district could say no. And there's no obligation, even if they do agree to meet, that you'll reach an agreement. The only way that you get to something that's binding on the district is if both parties agree and you sign an agreement with the terms that you're agreeing to. A due process hearing, on the other hand, is more like a trial. You're filing a complaint, laying out the allegations of how the school district violated your child's rights, and requesting relief for what you believe that they are entitled to receive. And then a hearing officer is appointed that will preside over a hearing that's like a mini trial and will make a decision and order the school district, ideally, to provide what you're looking for. But that's a much more intensive process, and we certainly don't advise parents to go through that alone without legal representation. The success rate when parents file due process on their own is dramatically lower than when they have an attorney. And the school district has the ability to have their attorney, regardless of whether parents have an attorney or not. So it can really be intimidating, and the deck can be stacked against you. And I hope that doesn't sound like an advertisement for our services. It's just an unfortunate reality. A lot of components of the IDEA and the law that were intended to protect parents have sort of been turned on their head and created these really procedurally dense and confusing methods to resolve disputes that require legal representation. This is my last slide and just gives you more information about how you can find forms and due process and other dispute resolution information from the state of Illinois, and then information on how to reach out to us if you have further questions. I am available to stay for about 10 more minutes or 15 minutes to answer questions. That I know that we've got some coming in, and that's great that we've had active participants. So I'd like to jump into questions, but then if we don't get to your question, my email is here at the bottom of this slide. You can email me at any time to ask questions that we don't get to, or if anything pops into your head after the presentation, please reach out to me.
Thank you so much. I've been getting, just so you know, I've been having messages come through this entire time. Just about how helpful this has been. So
Great.
Thank you so much. And I've had questions coming through, so I'll just go back and answer them or like ask them. And will this recording be accessible? So I am going to early next week send the recording to the affiliate staff and they can share. Yeah, so I will try to make it as accessible as I can to everyone. I'm also going to try to work with the university here in Chicago to see if they can help me translate into Spanish, because I know that would be helpful for some families as well. So one question that came across is, what is the difference between requesting and implementing Plan 504 in CPS public school and Catholic private school?
So private schools are not required to follow the IDEA. Private schools may be required to provide a 504 plan, which is more like accommodations that we talked about than it is services. or instruction. A lot of private schools do have service providers like speech therapists and social workers, and so that could be included in a 504 plan, but they're not required to follow the IDEA because they don't receive public education funding. But they are, just to be clear, they are what's called places of public accommodation. And that means that they can't discriminate on the basis of disability. So you could have an argument that a refusal to provide a certain service would deny your child an equal opportunity to benefit from their education, or is discrimination on the basis of disability. And you could argue for specific services under that theory. And that might be kind of hard to wrap your head around, but I'm happy to explain that further with your specific circumstances, whoever the questioner was, if you want to email me.
And the next question that came through was, okay, we are noticing that many schools are diagnosing ADHD and then autism or no autism so that they can control ESA dollars. If a family gets autism as a primary finding, they qualify in Arizona for ESA dollars, and then parents have the opportunity to pull the child to the best school possible out and no out-of-pocket cost. We are seeing retaliation towards parents when they fight the correct finding and making autism the primary. This is a big issue with families we support and want to know, how do we address this and what steps should families start with to resolve this primary reporting? That's a big question, but an important one.
Yeah, for sure. You know, what you can do on an individual basis is if you disagree with their determination, if you feel like they're making a determination that's not based on your child and your child's needs, but based on some other pressures, call that out. Call that out as a concern, and it should be included in the parent concerns or in the notes of the IEP. And then you can challenge it by filing a due process hearing if you feel like the eligibility category is wrong and that's impacting your child's education. Like I said, if the child is getting all of the services and supports that they need, regardless of eligibility label, then you'll have a hard time arguing that that the eligibility label needs to be changed, or that there's a negative impact for a hearing officer to address. But if it is impacting your ability to get services, then that's a valid reason to challenge it. And get clinical support from private evaluators on why they should qualify under autism.
The next question was, what is a multi-sensory reading program?
So that's a program that's designed for mostly for children with specific learning disabilities. And by multi-sensory, it means that children are learning through multiple senses. So they're reading, but they may also be tapping out the phonics of the word as they sound it out. They may be writing while they're reading. So it's really about, they may be hearing while they're reading. So multisensory really means using multiple senses to help encode the information to learn. And that's something that's based on research on what's helpful to remediate learning disabilities.
The next one was, what type of classrooms do they have in Chicago? In San Francisco, we have mild, moderate, or moderate, severe, or inclusion.
There are all types of programs. I've seen that type of setup before. Sometimes there are what are called cross-categorical classrooms where kids with different types of disabilities are included. Oftentimes that's not a great placement for kids with autism because some of the other categories may include kids who could be disruptive or distracting, If your child has sensory issues and they're in a classroom with other kids that have verbalizations or tics, that may be distressing or distracting. But then at the same time, we know that those are some symptoms that children with autism may have too. So sometimes even a child with autism being placed in a classroom with only other children with autism can be inappropriate for that child. So you really need to consider your child's individual needs and advocate for placement accordingly.
And next, what is the compensatory education that makes sense for not providing the one-to-one during COVID?
So that can be tough. What you really need to consider is, what was the impact of not providing the one-on-one aid? What can you demonstrate that your child lost out on because of that, right? So for the example, if your child really needed one-on-one help during reading to pay attention to the reading instruction, and you can show that they haven't made progress in reading that was expected, like if their IEP goals said they were going to be reading at a 3rd grade level and they're still at a 2nd grade level, you could make the case that that's in part because they didn't have the aid support that the team had agreed that they needed. And you can advocate for reading remediation, whether that's tutoring outside of regular school hours or a more intensive reading program to remediate that. Really, it can be anything that's necessary and agreeable. So, shoot for the moon, be realistic, but, advocate for what you feel is necessary.
So I have about 8 more questions. I don't know if we're going to get through all of them. How many more do you want me to go through?
I can go until 7:15. So
okay. All right. I'll just keep going. I'm just going in order. But this is really helpful. And some of this information is really, really awesome and helpful to share with our families and helpful for me too. So, okay. Are you familiar with SSCA corrective action to address students disadvantaged from IEPs for the previous school year? If so, should families accept the monetary offer or fight for additional supports for their child?
Yes, I'm familiar, and really it depends on your individual circumstances. Taking stock of what you feel like you may be entitled to or should receive on top of what's already being offered. I know some of the corrective action can seem paltry in comparison to what your child may actually need. So you may need to seek further advice from someone who can give you a realistic perspective on what you might be able to achieve. But then you also have to be honest with yourself about whether you're able to do that fight, right? To file a hearing request potentially if the school district.
That was my question. Is it okay to reach out to you guys to see?
Absolutely, yes.
Okay.
Please do.
Okay, thank you so much.
Yes.
Do all states have alternative dispute resolution?
Yeah, so that's usually what we refer to, that's a broad term. So mediation would be alternative dispute resolution, having a resolution session after you file a complaint. But you don't have to file a complaint to have dispute resolution. You can request mediation. You could even request a facilitated IEP if you feel like you need a neutral party to be at the IEP meeting to sort of run the show.
Next, what if they don't want to provide a daily log because they're trying to help my 5th grader be more independent and complete her own agenda, even though she does it 6 out of 10 times?
Well, one, I would say that should be a goal, right? For independence is completing the log more regularly. But That's a good example of how these things go hand in hand, accommodations and goals. Just because they want her to be more independent doesn't mean that they shouldn't provide information that you need, right? If it's something that's not realistic or achievable for your child, they should work on that, but they should also supplement it with the additional information that's needed, right? And one is not prohibitive of the other. They're not mutually exclusive. Your child can write her own log and they can supplement that as necessary, and you're still building towards independence. The child doesn't even, I mean, they'll probably know that the school's reporting as well, but that doesn't negate their need to create their own log.
Next is, what's the difference in an FSIQ versus a psychoeducational analysis? Why would a school do one or the other for eligibility determination?
Sorry, can you say again? I missed it. It cut out.
No problem. What's the difference in an FSIQ? So
Full scale IQ.
yeah, versus a psychoeducational analysis. Why would a school do one or the other for eligibility determination?
Well, they wouldn't. A full scale IQ is something that's determined through achievement testing, through psychoeducational testings, psychological evaluations. So I'm not sure if the reference to a psychoeducational analysis is a specific thing, but again, remember, school districts are required to complete broad evaluations, not use one measure to determine eligibility. So if a psychoeducational analysis in this question means a full psychological evaluation, then that would hopefully include more than just one achievement test. And that would be appropriate, I guess, just on the face of it. But of course, it depends on the results and how they do the test.
So I have 3 questions left. So I actually think we might be able to do it. So are young adults 18 through 22 protected by IDEA? If the CTC is out of compliance, can I file due process?
Yes, absolutely. Unless your child has graduated, received a diploma, and been matriculated out of the public school system by graduating, you're still entitled to services up to 22. And even if there's a lag in services, as long as you haven't actually graduated out, you're still entitled to come back and request services. And by the way, if you have aged out, but then you realize that something is missing or they did something wrong, you may be entitled to get compensatory education even after 22.
Does that include certificate of completion, Brad? If my son has a certificate of completion?
Yeah, I think that a certificate of completion is essentially the same as a diploma for these purposes. But I would want to know more about the specifics of what the certificate says to say for sure. So feel free to follow up with me if you're interested in getting more information on that. And by the way, I'm going to type my email in the chat box just so it's easily accessible. I know it's on the slides, but I'm just going to put it in the chat too. I see in the chat that someone says that they worked with me before, but I don't see your name. It just says Hippity.
Yeah, I saw that too.
Whoever that
I
is.
was wondering who that was.
You want to say hi?
Brad, it's Jim Otto.
Oh, hey, Jim.
Oh,
Nice to see you.
I didn't know who Hippity Hoppity was either, but I know now.
You know what? I should have known, Jim, because I have seen your Zoom before.
Exactly.
Yeah, thanks, Jim.
So 2 more questions. Well, it's already 7:16, but okay. Last question, I think. And then if you have a question, a couple more just came through now, but I think Brad sent his email so we can, thank you so much. And he's happy to answer questions. But it's a really good one to end on is, do you have a network of attorney advocates for IEPs that you work with in other states?
Not a firm, well, a network, yes. There's an organization called COPA, the Council for Parents, Attorneys, and Advocates. And so there is a way for me to find attorneys from that directory in various states. So I could help you out with that if you want. Otherwise, I just know, some people here and there from my experiences over the years. But if you're looking in a specific place and you want help, please let me know.
Thank you so much. We really
you,
appreciate your
everyone.
time, and thanks for reaching out to us and being willing to be here to provide us with this resource. We really appreciate it. And I'm happy to see so many people on Zoom. So it was great to see you all. And I will be sending out the recording early next week, and feel free to follow up with Brad for any additional resources or questions.